So building on all of these topics, limiting your liability, avoiding the loss of intellectual property, and limiting the likelihood of disputes, all of this is about building the business. So if you're building the business, what are you building it for? Well, you're building it for yourself, to be able to enjoy it, have a nice living perhaps. But something business owners often forget is to account for what happens after they're gone. If you work hard in the business and don't address the things that go along with the transfer after your life, unfortunately, the transfer can be not so easy. So let's say you have this business, you built it, and one day you're gone. If you have done no planning at all with how that business transfers, unfortunately, it will go through probate. In Ohio, probate takes between 6 to 12 months generally to transfer assets. It's very time consuming, and if your company is just a one or two person business, or it has many employees but you're the only one in control, unfortunately payroll can't be run, the bank accounts can't be accessed until someone opens probate and becomes appointed. And that can be a real drain on your company, because if there isn't a person in charge, there isn't a person making decisions, for every day that passes, more and more of the value of your company is being lost. You might be thinking, well, I have a will, it'll be fine. It's a common misconception that a will avoids probate. In fact, if a will is the only device that you have to distribute your assets, it will go through probate. Your company most certainly will, because the probate process is the transfer of everything in your name after your life that doesn't have beneficiaries or is not in a trust. And so in addition to general delay, the probate process is expensive. So you have the business that's worth, let's say, $350,000. Just to go through probate, the Hamilton County fee guideline for attorney compensation is over $13,000 just to simply transfer this asset from your name to the next generation. It's not a mandatory minimum or maximum, but this is a pretty good representation of what it would cost to just transfer the business. So let's look at an alternate version with the same facts. So again, you have a company. At your death, you are proactive and you have a transfer on death designation for the ownership of your business. So rather than your company being stuck in probate, it immediately transfers and there is absolutely no transfer cost. So that means after you pass away, as soon as a person has a death certificate, they can take over your business for you. So this could be a family member or it could be a transfer to your trust. And it would ensure that your asset that you work so hard to build isn't bogged down by a bureaucratic process. Now let's say you have more than one owner in your company. And upon the death of one owner, his or her interest will transfer. Now it may transfer to a spouse or a child, and in some cases that may be okay. You're perfectly willing to be a partner with the spouse or child of your deceased partner, but in many cases it's not okay. It's something that in fact you would prefer never happen. But if you haven't taken proactive steps, it's exactly what will happen, and it's likely there will be confusion as to how things will be administered, disputes on how to value the company, who is in control, and how the assets would be transferred. So a better option, something that is more proactive, is to create an operating agreement and a buy-sell agreement. So an operating agreement controls the operation of the day-to-day activities of a company. So this is really something that every LLC, every corporation should have, because it allows you to set forth standards for how the business operates, voting, all of the things that create disputes within the company can be resolved ahead of time by way of an operating agreement. And usually within that agreement, or as a separate side agreement, buy-sell provisions or a buy-sell agreement will address how assets, meaning ownership in the company, will be transferred after a person is deceased. So the buy-sell agreement will oftentimes have a calculation of value. So it may be at the time of death, the company is valued by an independent third party, perhaps a CPA, or upon one member's death, there's an equation used to calculate the value. There are many different ways to calculate the value of a small business, and it is typically a large point of contention if there is not a buy-sell agreement setting forth the exact calculation. Here, you can put that in place, and that will eliminate a lot of disputes. Also, control after death. If you want a family member to have control over your interest after you're deceased, this is the way to put forth voting rights and make sure that it's clear how the succession of ownership will pass after your life and who will control the company. The sale process. So if a value is calculated, control shifts to the existing member solely, and that process of sale could be immediate, meaning the surviving owner buys out the deceased owner's family, or it could be a payment over many years. So 3 years with a promissory note, or 5 years. It could be secured or unsecured, meaning there's collateral attached to the sale. But this allows for a clean structure to say the sale will be immediately after the person's death or will be over a period of time. And then life insurance. For some companies, they have life insurance policies in place so that if one of the members is deceased, the existing company doesn't have to pool resources out to pay for the sale of the business. Life insurance is very beneficial when you have larger companies where there's a lot of value built into the business, but yet if one person dies, it would be damaging to that business to have to pull out resources, sell equipment, or liquidate assets in order to pay for an exiting member.